Good morning, everyone. Welcome to today's webinar on what does the tenant fee ban mean for landlords. I'm just going to give 30 seconds or so for other attendees to join. I have been notified that a couple of people are running late, so just bear with us. Whilst we're doing that, we'll just do some housekeeping. On the bottom of your panel, you should be able to see a chat box. You can use this throughout if you want to ask any questions or discuss things amongst yourselves. If there is a specific question you'd like me to answer, you can put that through on a questions section as well. Do feel free to send over any emails if you're having any difficulties, and use that chat box to let me know if you can't hear or see the screen. So everyone should be able to see the slides on the screen. Okay, we'll get started. The webinar itself will be recorded and we will publish this on our YouTube channel. So if you do want to catch up later, you can do. So don't worry, you won't miss anything. Okay, first of all, I'll just do a quick introduction to MakeUrMove and myself. For those of you that don't know, MakeUrMove was established in 2008. The service was set up by landlords for landlords, and it was specifically to provide an alternative for both landlords and tenants rather than just a high street agent. Our whole ethos is to provide a supportive role to landlords and tenants, but remove costs and use technology. We are heavily focused on powering this with real people and real expertise. My position at the company, I was a co-founder. My personal experience comes from being a landlord and a tenant, and I have a passion for technology, which drives the solutions that we actually come up with. So what we're going to cover today, I'm sure everyone has heard or read about the tenant fee ban. Whether or not you actually understand what it is another matter. So the first thing we'll talk about is what the tenant fee ban is, the rules as they're currently set out within the proposals, what it would mean for agents, what it means for landlords, how you can prepare for it, and then we'll just run through any questions if we haven't been able to get through them during the presentation itself. So, the tenant fee ban. The tenant fee ban is a proposed outright ban on letting fees charged to tenants in England. Wales will have its own version. It's not going to be exactly the same as England, but largely the objectives are the same. So the main objectives behind this was to reduce the costs that tenants paid up front and remove all hidden charges that they're not able to calculate in advance. Promote a clearer service by agents, so point out to agents that it is landlords that are their clients and not tenants, and then create a balance of a relationship between landlords and tenants so that landlords are the people that need the service from agents, not tenants, and therefore they're the ones that should pay for it. This is the objective that the government has in these proposals. Is it yet law? No, is the short answer. The longer answer is that it is in draft. It is subject to change. It has been a long time coming. It was first announced some 3 years ago. There are different stages of how this gets through the passage of the bill to become law, but right now it has just had its report stage in the House of Lords, which is the second house to hear this draft. Yes, that was completed on Tuesday. The third reading is pending a scheduled date, but you would anticipate that now will be the new year. It won't be law until it receives royal assent, so it has to go through that final third reading stage, and then once it's assent, it will be enacted into law. We expect this to be at some point in 2019. There are a few suggestions that's going to be Easter time. At the moment, it's not looking likely. It's probably going to be more like autumn, but you would be wise to prepare for it being at April, May time. That way, then you're not going to get caught out if it does manage to get through a bit quicker. So just a quick understanding of how bills go through the houses to become law. So they can start in either house, the House of Commons or the House of Lords. This one started in the House of Commons. It had its first reading, then it had a second reading, followed by a committee stage, then a report stage, and then a third reading. And then it will go to the next house and have the same. After that, there is an amendment stage. So any amendments that have been tabled and passed will be added into and then it will receive royal assent. So the first reading is basically a discussion about what is proposed within the draft, and then there are some slight tweaks, and then the second one, the committee stage is where they will do calls for evidence, so they will speak to key parties that will be affected by the bill, so that this was in particular tenant voices. The Citizens Advice Bureau were there, Shelter were there, there was representatives from letting agents as well, ALA were there. Then you have the report stage and then the final third reading. It is important to point out that anything that we discuss in this webinar now is current proposals, and have updated these from Tuesday's readings. It's not necessarily going to be the exact way in which it will be enacted. So the rules that we're going to go over. The main rule of the tenant fee ban is that all and any fees that are charged to tenants related to the granting of, the continuance or renewing of, the assignment of, or the termination of an AST or license will be outright banned. Now, this will not extend to non-assured tenancies, and it will not extend to company let. So this is only assured short hold tenancies. My apologies for that. I'm not sure what happened. The whole webinar went down. There was a question. So just going to restart and get it re-recorded. I getting some confirmations that you can hear. Just checking you can also see the screen. Yeah, so we'll pick up where we left off, just discussing the rules that are currently proposed within the draft bill. The main one being that you're not allowed to charge any fees to tenants, and they are in relation to assured short hold tenancies, so that it doesn't extend to company lets or non-assured tenancies. And it is to do with either the granting of or renewing and assigning more than anything else. So what we mean by renewing is any renewals that you do. If they continue on a monthly basis, you're not allowed to charge fees for that. And if they then move out and assign the tenancy to someone else, you are not allowed to charge fees. The main thing to understand is that this includes any fees that will be paid on the tenant's behalf by someone acting for them. So this could be a guarantor, it could be parents if it's a student's let, for example. You cannot charge them fees either. And the other one that has been put forward as a workaround on this is to direct tenants to a specific reference agency in order to get them to collect a fee and potentially get some sort of feedback from that. That is also not permitted. You are not allowed to tell tenants where to pay fees to any third parties. This is also going to be included when we discuss things like where to pay utilities. So you do need to make sure that you're not directing tenants to pay any fees whatsoever to anybody in relation to this tenancy. Now, how that's going to be applied, really. We'll have a quick look at the example fees. Just checking that the screen is working. Oh dear. 1 second, please. Yep, I think that's working now. So apologies, there seems to be a bit of a connection issue with the webinar software. Okay, so we're going to look through some of the example fees that have been indicated within the draft bill. So credit and reference checks is the big one. This is the obvious one that most people would expect to cover. These will be banned, so tenants will not be paying for any credit or reference checks that you require them to do in order to give them a tenancy. So you cannot send them anywhere else to have this done and pay any fees to anybody else. Your only options are to cover the cost yourself or do them yourselves. So don't actually pay someone to do these for you. Inventories, this is a rather popular term within most tenancy agreements, that the one party will pay the ingoing inventory and one party will pay the outgoing inventory. That is not permitted. You are not permitted to share the cost of that inventory. Cleaning is another one, so professional cleaning or standard cleaning, you will not be allowed to charge. You won't be allowed to charge any admin fees. This is admin fees such as setting up the tenancy, so arranging for a signing of the tenancy, for replacing one tenant with another tenant. You won't be allowed to charge those fees to the tenants themselves. Gardening, that's also been included, and an early termination. Now, it's important to understand that early termination does not extend to the rent that would be due under the terms of the contract. What they mean by early termination in these examples is any fees in order to let a tenant be released from the contract. They're still bound by the terms of the contract up to the point at which you've released them. I think fees was actually a pretty big discussion in the third reading for the House of Lords as well. There's been lots of talk from lots of different companies that work within the industry about how you can get around these fees. I would go as far as to say that this bill going through the passages of the House of Lords and the House of Commons has been very, very closely looked at, and most of the little loopholes that were there have already been tied up. So I would not suggest it to be a good idea to any landlord or agent out there to try and use any workaround. The short answer is you cannot charge tenants fees once this comes in. So there are exemptions, so we'll run through these now. A holding deposit will not be classed as a fee, nor will rent and nor will deposits. So whilst you're allowed to collect a holding deposit, there is a limit on this, and it will be the equivalent of 1 week rent, and there are lots of further restrictions as well. So there are restrictions about how you hold the deposit and how it has to be returned. So the maximum time you can hold a deposit for is 15 days. You would then need to make a decision about whether or not you progress to a tenancy. And once you've made that decision, you have 7 days to either release the holding deposit or confirm to the tenant that you will be making any retentions. You are not permitted to retain the whole holding deposit unless you can prove that the information that's been provided by the tenant was done so with a view to misleading in order to get a tenancy. So it was either deliberately fraudulently provided, or it was a misunderstanding that they were aware of in order to try and mislead you. There is also likely to be a provision in there for you to retain the cost of the reference fee, and it has been proposed in the last reading that they will put a cap on what that cost can be. What would normally happen is they will set a fee that the maximum charge that you can return if the tenant has failed their referencing for reasons of providing misleading information. So it's likely that most people will bring that into their contracts and confirm that if the tenant fails for any reasons of information they've not provided it in advance, that there will be a retention from that fee, that this will be permitted. If you go on to grant a tenancy, you will be required to either return the holding deposit in full or put that holding deposit towards the rent and deposit. So you can't charge any fees once you go on to grant a tenancy. There will also be charges for defaults permitted under the exemptions. One such charge that has had significant discussion is the cost of changing keys, so changing locks and getting replacement keys. These will have a cap applied to them from the last discussion that's gone in. What that cap will be, we don't know yet. That you will be allowed to charge for late payment of rent, but it will need to be beyond a set number of days, and it will need to be a set interest rate level above the Bank of England base rate, and it will need to be clearly identified in your tenancy agreement. You will also be allowed to charge default fees for things such as reminder letters, but you must be advised that this has to be a reasonable fee, and if you are asked to do so, you must be able to provide evidence of the actual cost you have done in sending that letter. So the cost of the postage, for example, you will need to retain all of these things. Now the penalties. Now currently the penalties that are being put through, the main one to understand is that the local trading standards will be the enforcements behind this law. Tenants will be able to claim their money back, any fees that they have paid which are not permitted, through the county courts. There will be a fine of up to £5,000 on the first offence. Any subsequent breaches will then be considered a criminal offence, so they can be pushed through as in the criminal courts. But there is an alternative option to the trading standards at the moment, which is to give a fine of up to £30,000 and then a banning order. And there are discussions about adding in various other penalties such as rent repayments as well. So the crux of this is it is not worth trying to get around it, because these fines will be quite hefty. There has been some talk about whether or not there will be sufficient resource to enforce them. I would suggest that the amount of weight that has been put behind this from the government and from various parties, that they would expect these to be quite heavily enforced. So what does it mean for agents? Now, I'm not going to go on an agent bashing course here. It's nothing like that. The main issue, I think, for a lot of high street agents is that they will lose a significant revenue stream. And it has been reported that some agencies' revenue in this area is 25 to 60% of their overall revenue. As you can appreciate, that that is a significant amount of money to lose, especially seeing as there will still be a various amount of cost. Now, the tenant fee ban doesn't consider the amount of time and effort that either landlords or agents put into referencing, and it also doesn't consider the quality of any tenants that you would have, given the fact that you have done an exceptional service when it comes to referencing. The whole point of referencing is to understand your risk when offering a tenancy. The truth is if there's no skin in the game, as they say, then the tenants are less likely to be quite so transparent, which means that you have to be exceptional at doing your pre-vetting. You need to be aware of any potential risks that might be flagged, and you need to make sure that your question sets before you even get to a viewing, ideally, are set up in such a way that you are able to work out whether or not this tenant is likely to proceed. There are options for agents. There has been a lot of talk about job losses in the industry, and this could well be a possibility. It would be a shame. Hopefully agents will be able to work on other alternatives. One such alternative is to look at technology and efficiency within the service. So recommendations for agents is to have a look at your processes, see whether or not you can actually save time, costs by tweaking some of those processes. So when a tenant comes in, how do you process that lead? How are you then able to offer a viewing service? How would you then deal with a pre-vet on those tenants? And then can you do in-house referencing, etc.? These are all ideas. The main thing that I think most agents will do is sort of have their head in the sands when it comes to this. Is there has been talk about a complete lack of preparation when it comes to the tenant fee ban and how they're going to replace it. What that would probably lead to is an increase on landlord fees, which is the easy answer. There has been a lot of talk about agents telling landlords it's fine, you can increase your rent for the first 6 months and then drop down and that will cover our costs. That is not permitted under the tenant fee ban. You are not allowed to artificially inflate the rent. You are, however, permitted to increase your rents for the duration of a tenancy as long as it's consistent. So there is a way of recouping some of these losses. But as we all know, you increase landlord fees, then therefore rents would indirectly increase anyway. The other option that agents have is to drop let-only services and only concentrate on services that offer a full managed service, whereby it is in your interests to ensure that the tenants are of a good calibre, or reduce your services overall. So just don't do the referencing or do the referencing in-house, or reduce the requirement for credit checks. Ask tenants to provide all the information to you. These are all options that agents will face. I think the overwhelming majority will increase their fees, and that'll be the only way that they'll be able to deal with this. What does it mean for landlords? Now, obviously, if your fees increase and you're going to be paying more, you may well face a lower standard of service. You may have a heavier administrative requirement if you have to do some of these yourselves. You are going to have to look at the quality of these reference checks once this fee ban comes in and determine. It's your risk at the end of the day. Are you happy with the risk? Do you want to do further checks? Do you want to ask further questions? One of the things that we've not discussed here is that the deposits in the tenant fee ban has now been capped at 5 weeks. So it is likely that will come in that you will only be able to take a deposit of up to 5 weeks. Now, we've done a survey of our landlords, and our landlords generally only take a month anyway, so I don't think this is going to affect them. There has been a lot of discussions in the press about how these lower deposits are going to be a huge problem for landlords. Ultimately, I don't think they will be. An extra week is not going to make a massive issue. There have again been talks about how that extra week of deposit will be replaced in increased rents. I don't think it's necessary. I think there are various insurance policies out there that you can look at, which will protect your property and any furnishings or fixtures that you provide by making the tenants take that liability cover for you. So how can you prepare? I've gone through a few of the things for the agents. One thing to look at with the agents is check your subscriptions with various portals like Rightmove and Zoopla. They are doing quite a lot of work to try and help agents out, including bringing in rent passports, which has been suggested by a number of other reference agencies as well. This will maybe help you do some of your pre-vet, so you'll get a view of a credit file for a tenant, so you'll at least get the credit score. This is being trialled at the moment with Rightmove for various agencies in various places that hasn't been rolled out nationally, but they are planning to roll that out nationally next year. So just keep your eyes peeled for that, and it might be something that landlords start to see as well. Now, with landlords, the first thing you need to do really is check your agreements and paperwork. Our suggestion is that you do this now. Don't wait until you have to do it. Do it now in preparation. You need to remove any reference to checkout fees, inventories in, fees related to non-payment of rent, so instant fees for not paying rent on time. And you will not be able to charge these until a set number of days have occurred between the rent arrears and the time at which you can apply a charge. So you need to remove those fees. You need to check that your interest rate is in there and it's accurate with the current legislation. You also need to check any other paperwork. So any other reference application forms that you ask tenants to complete, you need to make sure that they either you know where it says that there's a reference fee so that you can remove that when the time comes, or remove it now and get used to the idea that these costs will start to be your costs. Ask your agent how they're going to deal with this next year. So get a view from your agent that you currently use in whether it's a let-only capacity or any other capacity, what are they going to do? Are they going to increase their fees? What are you likely to be facing as your costs next year? Then work out what type of service you would most benefit from. And what I mean by this is, are you DIY? Are you hands-on? Are you able to do most of these things yourself? And therefore, you then put a cost on your time, or are you able to outsource to an agent on a higher level? So would you prefer that then deal with your rent collection, deal with rent protection, deal with full management? Would that be a better use of your time than doing this yourself? Shop around is the obvious one, really. Take a look around, have a look at what other agents are doing, what other charges there are, whether or not there is a way for you to manage the whole advertising and let process yourself. And then the last one is to do the reference checks yourself, and also make sure that you cover all the other costs. And the key thing really is to understand what your income is versus your outgoings, and then you can work out where you have room, and whether or not you have to put your rent up. So ultimately you need to make sure that your rent is at a price where you still cover all of your outgoings at the very least, and hopefully make some sort of income. What are we doing? So I did say ask your agent. We're working on removing the tenant fees now. We, over the next few weeks, will be launching our new services. The services will be a complete removal of tenant fees, but we will be introducing an optional service where users can pay for advertising and then add on anything else they need. So if they want reference checks, they can have reference checks, and that goes to say with everything else as well. But we've also decided to bring in an all-inclusive service. So this will be a monthly service, a monthly fee, and it will include advertising, referencing, administration and report, and then support and legal assistance as well. And they can be used at any time throughout that subscription. So keep your eyes peeled for that information. If you're on our mailing list, stand up to our newsletter. If you're on our system, you will get an update once that goes through. We are expecting that to be completely updated on the site in January. Now, just to let you know, we've got our next webinar set for January next year, and we're going to look at disputed deposits and how best to deal with it, how to avoid it, and how to ensure that you get these dealt with quickly. Are there now any questions? I'm going to give a second or so. I'm just going to check the chat box. So let me apologise again for the drop off. I'm not entirely sure what happened. As a result, the recording might be a little bit off as well. So we will send round an email with a link for our YouTube recording. If it may work that we'll just send you these slides as well as a PowerPoint presentation so that you've got them, but we'll have a look and see what happens to the recording. Okay, there doesn't seem to be any questions. I hope I've managed to cover various bits on there for you. Do keep your eyes peeled on the news. If you are a member of associations such as the RLA, if you're an agent, you're a member of ARLA, you will get these updates from them as well as the tenant fee bill goes through its passage. Okay, that's great. There's no questions for anybody. Thank you very much for attending today. Do let us know if you've got any queries. If you'd like any further information, just drop us an email over and one of the team will get back to you. Otherwise, we look forward to seeing you on the next webinar, and just look out for your emails. Thanks, everybody.